Hello, everyone. Uh, I hope you all are staying safe and are in good health. So, here I come with my next lecture on the subject business law, that is, void agreements. Topic for today is void agreements. And as we have already discussed earlier, that one of the essential elements of a valid contract is that the agreement should not be declared void by the Indian Contract Act 1872. Two things that you need to remember over here is one is what is the meaning of void agreements. No matter what explanations are being given to you, how you understand it, how you interpret it, just remember one line. Void agreements are those agreements which can never take the shape of a contract. This means that no matter what explanations we try to give, how well we try to justify ourselves, a void agreement can never become a contract. So, the only line to remember the explanation for void agreements is void agreements are those agreements which can never take the shape of a contract. The other thing that you need to remember over here is that under this topic, you just need to explain the various agreements which have been expressly declared void by the Indian Contract Act 1872. So after this, in this presentation, I am going to explain you about the various agreements which are expressly declared void. By expressly declared void, we mean these are those agreements which have been clearly mentioned in the Indian Contract Act that these agreements are going to be void agreements. The takeaways from this particular session would be, first of all, you'll understand what is the meaning of void agreements. Number two, we'll try to highlight which are the expressly declared void agreements by law, and then there would be a conclusion. Now let's go on to the introduction, which I've already explained. It says, one of the essential elements of a valid contract is that it must not have been expressly declared void by law. And number two, a void agreement is not enforceable at a court of law. So, as we all know, that it is an agreement which is the basis of a contract, and for a contract to take place, there has to be an agreement. And if this agreement is a void agreement, it can never become a valid contract. So, void agreements are those agreements which have got no recognition in the eyes of law. These are the various agreements which have been expressly declared void by the Indian Contract Act 1872. Here you need to remember that I have mentioned various sections related to these agreements. So when you are framing your answer, it is suggested and it is recommended to mention these sections along with these agreements. Then only you can add value to your answer. And I have tried my best to keep these sections in order so that it's easy for you to remember and recall. Number one is agreements by incompetent parties. So if in any agreement we tend to see that the parties who are making themselves a part of an agreement are not capable of entering into a contract. Say, for example, if a party is a minor, or if a party is a person of unsound mind, or if a party is disqualified by law to enter into a contract, then immediately that particular agreement will become a void agreement. Say, for example, if I'm entering into an agreement with X and X is 15 years old, and here the basic requirement for the agreement is that this particular party should have the capability to contract, and as X is not 18 years old, this particular agreement will be called as a void agreement. It's an agreement with a minor. In the next lecture, I'm going to explain about capacity of parties, so it's going to be more clear when you just go through that video. Number two, agreements made under a mutual mistake of fact. If there is agreement whereby the parties are having some kind of confusion related to the goods that they are entering into a contract for, then we can say that as there is some kind of confusion, there is a mutual mistake of fact, so this agreement is a void agreement. Say, for example, if I have two cars. One is a red car and the other is a blue car. I want to sell off my blue car. I come to you and I say, will you buy my car for rupees 5 lakhs? And I want to sell my red car over here. But I just say, will you buy my car for rupees 5 lakhs? You feel that I'm selling my blue car. There is a confusion from my side only. I did not clarify which car am I interested in selling off. So you say, okay, I'm ready to buy your car. There is an agreement, and there is nothing wrong in two people who have the capacity to contract to enter into such kind of agreements. But when the time to finalize this particular agreement comes, we realize that there is a mutual mistake of fact related to which car about am I intending to sell and which car are you interested in buying. So, as there is confusion, there is no consensus ad idem. This particular agreement would be called as a void agreement. Next is agreements, the consideration or object of which is unlawful. Say, for example, if I enter into an agreement with you and I say that there is a guy in this campus, you just go and hit that guy. I'm going to give you rupees 1,000 for this. So, in case if I enter into such kind of agreement whereby one party is getting some money in return and the other party is getting some kind of satisfaction, which is in the form of beating the other person. So, this particular kind of consideration or the reasons for entering into this agreement is unlawful. So, it can never become a contract. Next is agreements made without consideration. Say, for example, if I have an expensive mobile, say it's for worth rupees 50,000, I sell, I just give this mobile to you, not as a gift. I give it to you without anything in return. So this particular agreement will be termed as a void agreement. But yes, if I give this mobile to you as a gift, it would not be termed as a void agreement because it is an exception to this. Next is agreements in restraint of marriage. Restraining means to stop somebody from entering into something. So if I say agreement in restraint of marriage means if I enter into an agreement with you and I take a promise from you that is you will never marry in your life. And in case if you give me this promise, I'm going to give you rupees 10,000 per month. You enter into an agreement, you start taking rupees 10,000 from me per month for say 3 years. And in the fourth year, you end up getting married. So here I have no particular, I cannot enforce this agreement in a court of law because here if I go to the court and if I explain this agreement to the people over there, it would be me who would be taken as wrong. It would be said that it was my fault that being a major, I entered into a void agreement, so I have to bear the consequences. Consequences would be losing you as a person because you are married now, and the other is that I have already given you rupees 10,000 per month for 3 years. I cannot even claim that money back from you. Next is agreements in restraint of trade. Just like there is agreement in restraint of marriage, there is agreement in restraint of trade. Means stopping somebody from entering into a business that that person may be good at. Say for example, if me and X, we are staying in a particular area and I already have a running business in that area. Say for example, if I have a boutique and I'm doing very well, but I'm aware of the fact that if X comes up with a boutique in that area, then X is going to prosper, X is going to flourish more. So I do not want any kind of competition in my business. So I enter into an agreement with X and I say that you promise me that you will never open any kind of business, you will never start any kind of business related to this boutique, and I'm going to give you rupees 10,000 per month. So X enters into an agreement with me. Again, X takes money from me per month, 10,000 for a period of say 2 years. And then in the third year, X ends up opening a boutique in my area. So if I cannot enforce this agreement in a court of law, because if I try to do so, I would be told that it was my fault that I entered into a void agreement, so I have to bear the consequences. Next is agreement in restraint of legal proceedings. That is, entering into such agreement whereby we are trying to stop somebody from taking some sort of legal action against anybody. If we are doing so, we are making ourselves a part of a void agreement. Say, for example, if X and Y are, and me, X, Y, and Mita, we three of us are very good friends. There is a fight between X and Y, and X is so angry that X wants to take some kind of legal action against Y. So I do not want my friends to fight. So what I do is I go to X, I say रहने दो, थोड़ी बहुत गलती हो गई है, छोड़ दो उसको. Don't take any kind of legal action. X बहुत गुस्से में है. X says that no, I'm going to take a legal action no matter what. So I say you keep this amount of rupees 2 lakh, तो 2 लाख रुपए रख ले, शांति से बैठ. Please do not take any legal action against Y. So here, what am I doing? I'm trying to stop somebody from taking a legal action which the person wanted to. So if X is smart, what X would do is that X would take that amount from me, that is amount of rupees 2 lakhs, and say after a couple of months, X would end up taking a legal action against Y. And if something like this happens, I cannot enforce this agreement in a court of law, because court would say that it was my fault that I made myself a part of a void agreement, so I have to bear the consequences. Next is agreements, the meaning of which is uncertain. This is a very nice point. Say, for example, if I am a dealer of oil. Just to explain this, I'm explaining with the help of an example. And let me tell you, dear participants, that if you explain the subject with the help of examples, more and more examples, better your answers would be, better your clarity would be, and better marks you can score. So try to quote as many examples as you can, and try to quote as many sections as you can remember. So when we say agreements, the meaning of which is uncertain, I'm quoting the example that, say for example, if I am an oil dealer, अगर मेरा ऑयल का बिजनेस है जहां पर अलग अलग टाइप के ऑयल मिलते हैं, coconut oil, mustard oil, and sesame oil. These are three types of oil that I'm dealing in. So if I enter into an agreement with a party, say X, and I agree to sell oil, say for 100 rupees per liter. So here there is a problem. That is, I haven't made it clear which oil am I talking about. I have to mention the kind of oil that I'm going to sell to the party X. In case if I do not give this clarity to my agreement, it would be termed as a void agreement. But again, there is a little exception over here. Say for example, if I am a dealer of only mustard oil, and I enter into an agreement with X, and I say I'm going to sell oil for rupees 100 per liter. So here the meaning is it's not uncertain, because I'm dealing only in one type of oil. It is understood if I'm entering into such agreement, I'm talking only about mustard oil. Next is agreement by way of wager. Wagering agreements are those agreements, the meaning of which is like the happening of which is depends upon some kind of contingency, which may or may not happen. Say, for example, lottery tickets. If I buy a lottery ticket, basically, what is the reason for buying this lottery ticket? There are two parties, me and the other is a person who is selling the lottery ticket. So I'm going to pay money for the lottery ticket. That is the consideration of the person selling the lottery ticket. And what would be my consideration? I may or may not get my consideration. अगर जो नंबर इस टिकट पे मेंशन्ड है वो नंबर यदि निकलता है तो डेफिनेटली मुझे मेरा कंसिडरेशन मिल जाएगा, दैट इज द प्राइस अमाउंट. पर यदि वो नंबर नहीं निकलता है तो मुझे मेरा कंसिडरेशन नहीं मिलेगा, and there would be one party which would get consideration and the other party will not get a consideration. So when we say agreement by way of wager, मतलब ये इसमें consideration मिल भी सकता है, नहीं भी मिल सकता है. So if it is this type of agreement, it will not be recognized by law because it will come under the category of void agreements. And to a certain extent, because of this only, the selling of lottery tickets have been banned all over the country. Next is agreements to do impossible acts. If we are entering into an agreement whereby we are trying to get ourselves involved in doing some kind of impossible act, just remember two examples for this thing, that is getting the stars or making two parallel lines meet. If I enter into an agreement with you, I say if you give me rupees 10,000, I can make two parallel lines meet. Both of us are aware of the fact that I cannot make two parallel lines meet. If I say you give me rupees 50,000, I'll get two stars from you from the sky. You also know I cannot do that. If I'm entering into any such kind of agreement, it is a void agreement because we are making ourselves a part of an agreement whereby we are trying to make we are promising some kind of impossible act which will never happen. Now, there are certain objective type questions. I could just think of these three to have a quick recap. One is a contract with a minor is dash, that is which agreement it is. An agreement in restraint of marriage is dash. A void agreement is not dash at a court of law. In case if you have any kind of doubts related to this particular topic, I am always available on this mail ID of mine. You can connect to me and for further clarification. That will be all for this topic. Thank you so much.